Hello everyone, Kit here, back here with part 4 of this act. So without any further ado, I'm going to get right into it. The statutory text of the act is also supplemented by these comments, which, like the comments to any uniform act, may be relied on as a guide for interpretation. Interpreting Uniform Commercial Code, Yale University versus Blumenthal. Interpreting Uniform Management of Industrial Funds. Jack Davis's Legislative Law and Process in a nutshell. The text of and comment to this section are based on Uniform Trust Code, Section 106, and its accompanying comment. Article 2. Creation, revocation, and amendment of power of appointment. Section 201. Creation of power of appointment. Section A. A power of appointment is created only if 1. The instrument creating the power is valid under the law of this state, and 2. The terms of this instrument creating the power manifest the donor's intent to create in a power holder a power exercisable in favor of a permissible appointee over appointed property. B. A power of appointment may not be created in a deceased power holder. C. Subject to any applicable rule against perpetuities, a power of appointment may be created in an unborn or uncertified power holder. Comment. Where did I go? Right here. Comment. An instrument can only create a power of appointment if the instrument itself is valid. Thus, for example, a will creating a power of appointment must be valid under the law, including choice of law, applicable to wills. An inter vires trust creating a power of appointment must be valid under the law, including choice of law, applicable to inter vires trusts. In part, this requirement of validity means that the instrument must be properly executed to the extent to the other law imposes requirements of execution. In addition, the creator of the instrument must have the capacity to execute the instrument and be free from undue influence on other wrongdoing. On questions of capacity, see Reinstatement Third of Property, Wills, and Other Donated Transfers, Section 8.1, Mental Capacity, and 8.2, Minority. The ability of an agent to make a power of appointment on behalf of a principal is determined by other law, such as the Uniform Power of Attorney Act on freedom from undue influence and other wrongdoing. See, e.g., Reinstatement Third of Property, undue influence, duress, or fraud. If the instrument is valid, the terms of the instrument must also manifest the donor's intent to create in one or more power holders a power of appointment over appointed property. This manifestation of intent does not require the use of particular words or phrases, but careful drafting should not leave no doubt that the transferor's intent. Sometimes the instrument is poorly drafted, creating the question of whether or not the donor is intended to create a power of appointment. In such a case, determining the donor's intent is a process of construction. On construction generally, see chapters 10, 11, and 12 of the Reinstatement of Third Property, Wills, and Donative Transfers. See also more specifically Reinstatement Third of Property, Wills, and Other Donative Transfers. Section 8.1. Comments B to G containing any illustrations of language ambiguous about whether a power of appointment was intended, and such illustration offering guidance about how to construe the language. The creation of power of appointment requires that there be a donor, a power holder who may be the same as the donor, and appointed property. There must also be one or more permissible appointees. Through these do not be restricted, a power holder can be authorized to appoint to anyone. A donor is not required to designate a taker in default of appointment, although a well-drafted instrument will specify one or more takers in default. Subsection B states the well-accepted rule that power of appointment cannot be created in a power holder who is deceased. If a power holder dies before the effective date of an instrument purporting to confer a power of appointment, the power is not created. An attempted exercise of the power is ineffective. For example, the effective date of a power of appointment created in the donor's will is the donor's death, and when the donor executes the will, the effective date of a power of appointment created in a donor's inter vires trust is the date this trust is established, even if the trust is revocable. See Reinstatement Third of Property, Wills, and Other Donative Transfers, Section 19, Period 11. Comments B and C. If the power holder is deceased on the relevant date, the power of appointment is not created, and the attempt of the power holder to exercise the power is ineffective. Nor if a power of appointment is created if all the possible permissible appointees of the power are deceased, when the transfer is intended to create the power becomes legally operative. If the possible principal appointees of the power die after a power is created and before the power holder exercises the power terminates. A power of appointment is not created if the principal appointees are so indefinite that it is impossible to identify any person to whom the power holder can appoint. If the description of the principal appointees is such that one or more persons are identifiable, it is not but possible to determine whether or persons are within the description. The power is validly created, but an appointment can be made to persons who can be identified as within the description of the principal appointees. Subsection C explains that a power of appointment can be conferred on an unborn or uncertain power holder, subject to any pliable rule against perpetuaries. This is a postponed power. The power arises on the power holder's birth of ascertainment. The language creating the power, as well as other factors such as the power holder's capacity, under pliable law, determine whether the power is presently exercisable, postponed, or testamentary. The rules of this section are consistent with, and this comment draws on reinstatement third of property, wills, and other derivative transfers, and the accompanying commentary. Section 202. Power to revoke or amend. A donor may revoke or amend a power of appointment, but only to the extent that 1. The instrument creating the power is revoked by the donor, or 2. The donor reserves the power of revocation or amend it in the instrument creating the power of appointment. Comment. The donor of power of appointment has the authority to revoke or amend the power only to the extent of the instrument creating the power is revocable by the donor, or the donor reserves the power of revocation or the amendment of the instrument creating the power. For example, the donor's power to revoke or amend a will or revocable inter vires trust carries with it the authority to revoke or amend any power of appointment created in the will or trust. However, to the extent that of an exercise of the power removes an appointed property from a trust, the donor's authority to revoke or amend the power is limited, unless the donor expressly reserved authority to revoke or amend any transfer from the trust after the transfer is completed. If an irrevocable trust inter vires confers a presently exercisable power on someone who is not the settlor of the trust, the settlor being the donor of the power, if the donor lacks authority to revoke or amend the power, except to the extent that the donor reserved the authority to do so, if the donor did not reserve the authority to revoke or amend the power, that authority is only effective until the power holder irrevocably exercises the power. If the same individual is both the donor and the holder of a power of appointment, the donor in his or her capacity as power holder can indirectly revoke or amend the power by a partial or total release of the power. See sections 401. After the power has been irrevocably exercised, however, the donor has no different position in regard to revoking or amending the exercise of the power than the donor would have been if the donor and power holder were different individuals. The ability of an agent to revoke or amend the power of appointment on behalf of a principal is determined by other law, such as the Uniform Power of Attorney Act. This rule of this section is consistent with, and this comment draws on, reinstatement third of property, wills, and other derivative transfers, and the accompanying commentary. Article 3. Exercise of power of appointment. Section 301. Requisites for exercise power of appointment. A power of appointment is only exercised only if 1. The instrument exercising the power is valid under the law of this estate. 2. The terms of the instrument exercising the power. A. Manifests the power holder's intent to exercise the power, and B. Subject to Section 304. Satisfy the requirements of exercise, if any, imposed by the donor, and 3. The appointment is permissible exercise of the power. Comment. Paragraph 1. States the fundamental principle that an instrument can only exercise the power of appointment if the instrument itself is valid. Thus, for example, a will exercising in power of appointment must be valid under the law, including the choice of law, applicable to wills. An inter vires trust exercising power of appointment must be valid under the law, including choice of law, applicable to those vires trusts. In part, this means that the instrument must be properly executed to the extent of other law employs the requirements of execution. In addition, the creator must have the capacity to execute the instrument and be free from undue influence and other wrongdoing. On questions of capacity, see Reinstatement Third of Property, wills and other derivative transfers. On freedom from undue influence and other wrongdoing, see Reinstatement Third of Property, undue influence, duress, or fraud. The ability of an agent to exercise the power of appointment on behalf of principal is determined by other law, such as the Uniform Power of Attorney Act. Alright guys, I'm going to be off here, and I'll see you guys in the next video. Bye.